I declare monopoly!
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
I'm already getting winded trying to inflate this thing. Can you guys see how red my face is? Okay, I probably only have a little more to go, and then I'm gonna go need to take a break. We're almost there. So far, this is what we've got. This is pretty epic. All right, so there we go. It might be just a little bit larger than I anticipated. I really don't know what I was thinking when I did this. I saw it at the store and I just had to grab it. Okay. So out of the Northern District of California, in the Epic Games versus Apple Inc. case lawsuit, we have the order granting in part and denying in part the motion for a preliminary injunction. The judge does a great job of explaining everything, and it's very long, so we're going to go through it. I'll try to put chapters, and you can just sort of click wherever you want to click. And I already read through it once, sort of skimming it. It's actually really good. The judge does a really good job of summarizing the situation and the law, and they get to the part that I'm really interested in is how are they going to define the relevant market for the antitrust claims. So without further ado, and further explanation from me, and further delay, let's go. Preliminary injunctive relief is an extraordinary measure rarely granted. Plaintiff Epic Games Inc.'s lawsuit against defendant Apple Inc. challenges the fundamental operation of digital platforms affecting millions of users. To resolve it, the court must apply the Sherman Act, California's Cartwright Act, and California's unfair competition law, statutes enacted more than a century ago, to a technology context where lawyers and economists can merely hypothesize about the future of the digital frontier. While courts are charged with adjudicating cases of significant impact, they do so cautiously and on full records, with the status quo intact. In this motion for the preliminary injunction, Epic Games asks the court to force Apple to reinstate Fortnite to the Apple App Store, despite its acknowledged breach of its licensing agreements and operating guidelines, and to stop Apple from terminating its affiliates' access to developer tools for other applications, including Unreal Engine, while Epic Games litigates its claims. Having carefully considered the parties' arguments and for the reasons set forth more fully below, the court maintains its findings from the temporary restraining order and hereby grants in part and denies in part Epic Games' motion for a preliminary injunction. So the short version there, since this is very long, let's summarize it. The short version is that the court is going to deny the forced re-entry of Fortnite into the Apple App Store, but allow the affiliated developers of the Unreal Engine to continue to have their access because they're sort of the victims of this whole thing and not really part of the battle between Epic and Apple. But that's not the interesting part, that's just the result. Let's get to it. Epic Games bears the burden in asking for such extraordinary relief, a preliminary injunction. Given the novelty and the magnitude of the issues, as well as the debate in both the academic community and society at large, see this investigation of competition in digital marketplaces from the Subcommittee on Antitrust, Commercial, and Admin Law of the Committee on the Judiciary, which is from the United States House of Representatives. The court is unwilling to tilt the playing field in favor of one party or the other with an early ruling on likelihood of success on the merits, which is a part of preliminary injunction law. That's a requirement. Epic has strong arguments regarding Apple's exclusive distribution through the iOS App Store and the in-app purchase system through which Apple takes 30% of certain IAP payments. However, given the limited record, Epic Games has not sufficiently addressed Apple's counter-arguments. The equities addressed in the temporary restraining order remain the same. Background. The court summarizes the limited record before it on its motion for preliminary injunction. To expedite issuance of this order, the court cites to some of the basic background from its prior order, as the background is equally relevant here. The court notes disputes in the evidence where otherwise appropriate. The relationship between Epic Games and Apple dates back to 2011, when Epic Games released Infinity Blade on the iOS platform. Epic Games and Apple collaborated for several Apple events showcasing Epic Games' iOS games and earlier iterations of the Unreal Engine running on iOS and macOS. Following the success of Fortnite, Epic launched Fortnite on iOS in April of 2018, where it remained on the platform until August 13th, 2020. During that time period, 116 million iOS devices accessed Fortnite, spending more than 2.86 billion hours in the game. The daily average users numbered approximately 2.5 million on iOS, representing 10% of Fortnite's total average daily players, and 63% of iOS players on Fortnite have only accessed Fortnite from an iOS device. Finally, iOS users accounted for more IAPs within Fortnite than those on Android, but iOS users spend less on IAPs than those on consoles, including PlayStation and Xbox. On June 30th, 2020, the developer programming license agreements were renewed. That same day, Epic Games founder and chief executive officer Tim Sweeney sent an email to Apple executives, including Tim Cook, requesting the ability to offer iOS consumers competing payment processing options other than Apple payments without Apple's fees in Fortnite and other Epic Games software distributed through the iOS App Store, and 2, a competing Epic Games Store app available through the iOS App Store and through direct installation that has equal access to underlying operating system features for software installation and update as the iOS App Store itself has, including the ability to install and update software as seamlessly as the iOS App Store experience. Mr. Sweeney highlights that those two offerings would allow customers to pay less for digital products and allow developers to earn more money. Mr. Sweeney also wrote that he hoped that Apple would also make these options equally available to all iOS developers in order to make software sales and distribution on the iOS platform as open and competitive as it is on personal computers. In this email, Mr. Sweeney does not provide any offer to pay Apple any portion of the 30% it charges on either app distribution or for in-app purchases. On July 10th, 2020, Apple Vice President and General Counsel Douglas G. Vedder responded to Mr. Sweeney's email with a formal letter. In short, Apple's response to Epic Games' request was no. Both requests were unequivocally refused. As relevant here, with respect to the Epic Games Store request, Mr. Vedder wrote, "Apple has never allowed this, not when we launched the App Store in 2008, not now. We understand this might be in Epic's financial interests, but Apple strongly believes these rules are vital to the health of the Apple platform and carry enormous benefits for both consumers and developers. The guiding principle of the App Store is to provide a safe, secure, reliable experience for users and a great opportunity for all developers to be successful. But to be clear, when it comes to striking the balance, Apple errs on the side of the consumer." Mr. Vedder also reiterated that Epic Games' request to establish a separate payment processor would interfere with Apple's own system, the business model of which has been used in the App Store since its inception. On July 17, 2020, Mr. Sweeney responded to what he described as a self-righteous and self-serving screed, writing that he hoped Apple someday chooses to return to its roots, building open platforms in which consumers have freedom to install software from sources of their choosing, and developers can reach consumers and do business directly without intermediation. He stated that Epic Games is in a state of substantial disagreement with Apple's policy and practices, and promises that it would continue to pursue this as it has done in the past to address other injustices in the industry. I wonder how Mr. Sweeney would feel if I wanted to put the Lawful Masses App Store on Epic App Store for free. I wonder what his thought would be about that. In fulfilling Mr. Sweeney's promise to pursue this perceived injustice, Epic Games covertly introduced a hotfix into the Fortnite version 13.40 update August 3rd, 2020. Epic Games did not disclose the full extent of this hotfix to Apple, namely that this hotfix would enable a significant and substantive feature to Fortnite, permitting a direct pay option to Epic Games that would be activated when signaled by Epic Games servers. Until this signal was sent out, the direct pay option would remain dormant. When activated, however, this direct pay option would allow iOS Fortnite players to choose a direct pay option that would circumvent Apple's IAP system. Relying on the representations that intentionally omitted the full extent and disclosure of this hotfix, Apple approved of the Fortnite version 13.40 to the App Store. Epic Games disputes that its use of the hotfix was deceptive, where it is common practice. The deception is not from Epic Games' use of a hotfix, it is from the use of a hotfix clandestinely to add features in violation of the guidelines and its agreements with Apple, and then failing to disclose such to Apple. The hotfix remained inactive until the early morning of August 13, 2020, when Epic Games made the calculated decision to breach its allegedly illegal agreements with Apple by activating the undisclosed code in Fortnite, allowing Epic Games to collect IAPs in-app purchases directly. Fortnite remained on the App Store until later that morning when Apple removed Fortnite from the App Store, where it remains unavailable. And I've said this before several times, but I'll say it again. If they had simply not done that and filed this lawsuit, they wouldn't be losing the revenue from Fortnite and the App Store right now. It's an unclean hands situation where they should have, I don't know which way to hold this thing, where they should have not done that. They should have refrained from actually enacting the change, instead getting the courts to intervene before actually making the change. Later that same day, Epic Games filed this action and began a pre-planned and blistering marketing campaign against Apple. This marketing campaign included a large-scale Twitter campaign, a releasing of a parody video of the iconic Apple 1984 commercial, a Fortnite tournament in support of its lawsuit with in-game prizes, and a releasing of a limited-time skin in Fortnite called the Tart Tycoon, modeled presumably on Mr. Cook's likeness. The following day, Apple responded sternly. It informed Epic Games that, based on its breaches of the App Store guidelines and the Developer Program License Agreement, it would be revoking all developer tools, which would preclude updates for its programs and software. Apple gave 2 weeks to comply with the App Store guidelines and agreements. Apple also identified general consequences for any failure to comply, but specifically cited Unreal Engine as potentially being subject to harm should Epic Games fail to comply within the 2-week period. Thereafter, on August 17, 2020, Epic Games filed the request for a temporary restraining order, which is kind of like a preliminary injunction, but is just shorter in time. It happens quickly, it can happen ex parte, and it only can last for 2 weeks. Requesting the reinstatement of Fortnite with its activated hotfix onto the App Store. So with its activated hotfix, not the old status quo, but something new that wasn't status quo before. And the preliminary injunction and temporary restraining order motions are supposed to maintain the status quo. So again, unclean hands. And to enjoin Apple from revoking the developer tools belonging to its Epic affiliates. They did win that, and the court will uphold that here, that Unreal is not related to this and those affiliates should not be punished. So it's going to maintain the status quo there, which was that the hotfix in Fortnite is the problem, not the Unreal Engine. The court declined to reinstate Fortnite onto the App Store, but temporarily restrained Apple from taking any action with respect to the Epic affiliates' developer tools and accounts. On August 27, 2020, as planned by Epic Games, an updated version containing Season 4 of Fortnite was released on all platforms except for iOS, which Epic Games could no longer update due to its breaches of the Apple agreements and guidelines. By design, Fortnite users can only play amongst other users currently operating the same version. Because of this release, iOS Fortnite players no longer had the ability to play cross-platform with other players unless these players chose not to update their version, foregoing playing in the new season. On August 28, 2020, on the expiration of the 2-week deadline, Apple terminated Epic Games' developer program account, referenced as Team ID number 84, stating Apple is exercising its right in Apple's sole discretion to terminate your status as a registered Apple developer pursuant to the agreement and is terminating the developer agreement and program license agreement pursuant to their terms. We will deny your reapplication to the Apple developer program for at least a year. Following this, the parties engaged in briefing on the motion for a preliminary injunction on a slightly expedited basis. The court heard oral argument on the motion September 28, 2020, which we covered a little bit of that. Legal framework. Preliminary injunctive relief, whether in the form of a temporary restraining order or a preliminary injunction, is an extraordinary and drastic remedy that is never awarded as of right. It is so well settled as to not require a citation of authority that the usual function of a preliminary injunction is to preserve the status quo during litigation pending a determination of the action on the merits. I think ante litem is before litigation. A preliminary injunction is not a preliminary adjudication on the merits, but rather a device for preserving the status quo and preventing the irreparable loss of rights before judgment. In order to obtain such relief, plaintiffs must establish 4 factors. They are likely to succeed on the merits, they are likely to suffer irreparable harm in the absence of relief, the balance of equities tips in their favor, and an injunction is in the public interest. With respect to the success of the merits and balance of harms factors, courts permit a strong showing on one factor to offset a weaker showing on the other, so long as all 4 factors are established. In other words, if a plaintiff can only show that there are serious questions going to the merits, a lesser showing than likelihood of success on the merits, then a preliminary injunction may still issue if the balance of hardships tips sharply in the plaintiff's favor, and the other 2 winter factors are satisfied. This is, of course, from Winter versus Natural Resources Defense Council, which is the Supreme Court case where we get these preliminary injunction rules. Thus, under the Ninth Circuit's sliding scale approach to these factors, when the balance of hardships tips sharply in the plaintiff's favor, the plaintiff need demonstrate only serious questions going to the merits. Analysis. The court finds it appropriate to evaluate once again Apple's actions with respect to 1. Epic Games specifically, including the delisting of Fortnite and other games authorized under Epic Games' contract with Apple, and 2. The attempt to suspend and terminate developer rights authorized under other contracts, such as the one controlling Unreal Engine. Likelihood of success on the merits. Epic Games brings 10 claims for violations of the Sherman Act, California Cartwright Act, California Unfair Competition Act. For purposes of the motion for preliminary injunction, Epic Games focuses on 2, the monopoly maintenance claim under Section 2 of the Sherman Act and the tying claim under Section 1 of the Sherman Act. Accordingly, the court cabins its analysis with respect to these only. Having reviewed the limited record while Epic Games raises serious questions on the merits, the court cannot conclude that Epic Games will likely succeed on the merits of those claims. Too many unknowns remain. So that doesn't mean that they won't succeed on the merits. It's the judge saying that there's not enough in the record to say that they are likely to succeed on the merits yet. It is not a full adjudication. It's just that they didn't win the preliminary injunction. So if you really want Epic Games to win, that's still possible. The judge is not saying that that's not possible. She's just saying that there are too many unknowns. The current legal landscape cautions against preliminarily finding antitrust violations based on a less than full record. As the parties acknowledge, this matter presents questions at the frontier edges of antitrust law in the United States. Simply put, no analogous authority exists. The questions and issues raised in this litigation concern novel and innovative business practices in the technology market that have not otherwise been the subject of antitrust litigation. As the Ninth Circuit recently recognized in FTC versus Qualcomm, novel business practices, especially in technology markets, should not be conclusively presumed to be unreasonable and therefore illegal without elaborate inquiry as to the precise harm that they have caused or the business excuse for their use. This is because innovation involves new products and business practices. Courts and economists' initial understanding of these practices will skew initial likelihoods that innovation is anti-competitive and the proper subject of antitrust scrutiny. The court, therefore, has an even greater obligation to conduct an elaborate inquiry before determining that the alleged practices violate antitrust law. Second, the record remains insufficient to conclude that Epic Games will likely succeed on the merits of its claims. As discussed below, the record includes conflicting evidence in support of both Epic Games and Apple, a lack of crucial evidence without which the merits cannot be determined, and fundamental disagreement by expert witnesses that is not resolvable at this stage of the case. With respect to the last, the court highlights that the parties' retained expert witnesses are all accomplished and distinguished individuals. Epic Games submits declarations from Dr. David S. Evans, an economist with degrees from the University of Chicago, whose scholarly work has been widely read and cited, including by the Supreme Court in Ohio versus American Express. Apple submits declarations from Dr. Richard Schmalensee, an economist with degrees from the Massachusetts Institute of Technology, whose work is also widely read and cited, including in Amex and Microsoft, and Dr. Lauren Hitt, an academic with a business management background and degrees from MIT and Brown, who has background in electrical engineering and technology. These expert reports reflect fundamental disagreements from luminaries in the field as to the foundational questions of this matter. While ultimately one view will likely prevail, at this juncture the court concludes that reasonable minds differ. With these considerations in mind, the court turns to the merits of the claims. Monopoly maintenance under Section 2 of the Sherman Act. In order to prevail on its theory that Apple engaged in unlawful monopolization under Section 2 of the Sherman Act, Epic Games must show A. the possession of monopoly power in the relevant market, B. the willful acquisition or maintenance of that power, and C. causal antitrust injury. A threshold step in any antitrust case is to accurately define the relevant market, which refers to the area of effective competition. Monopoly power under the first element can be defined as the power to control prices or exclude competition and may be inferred from defendants' predominant market share in the relevant market. In addition, courts usually cannot properly apply the rule of reason without an accurate definition of the relevant market. Without a relevant market definition, there is no way to measure the defendant's ability to lessen or destroy competition. The relevant market must include both a geographic market and a product market. The latter must encompass the product at issue as well as all economic substitutes for the product. Economic substitutes have a reasonable interchangeability of use or sufficient cross-elasticity of demand with the relevant product. Including economic substitutes ensures that the relevant product market encompasses the group or groups of sellers or producers who have actual or potential ability to deprive each other of significant levels of business. Illegal power must be appraised in terms of the competitive market for the product. In some instances, one brand of a product can constitute a separate market. The law permits an antitrust claim to restrict the relevant market to a single brand of the product at issue. However, such single brand markets are, at a minimum, extremely rare, and courts have rejected such market definitions even where brand loyalty is intense. See the Apple v. SciStar Corp case. That's where I believe SciStar wanted to make Macintosh computers and Apple said no. And that was still not considered a monopoly. But also in SciStar, antitrust markets consisting of just a single brand, however, are not per se prohibited or automatically prohibited. In theory, it may be possible that in rare and unforeseen circumstances, a relevant market may consist of only one brand of a product. Nevertheless, it is legally permissible to premise antitrust allegations on a submarket or an aftermarket. A submarket is economically distinct from the general product market. There are several practical indicia of an economically distinct submarket, including industry or public recognition of the submarket as a separate economic entity, the public's peculiar characteristics and uses, unique production facilities, distinct customers, distinct prices, sensitivity to price changes, and specialized vendors. An aftermarket is wholly derivative from and dependent on the primary market. An aftermarket may constitute the relevant market where market imperfections such as information and switching costs prevent consumers from realizing that their choice in the initial market will impact their freedom to shop in the aftermarket. Thus, determining the relevant market can involve a complicated economic analysis, including concepts like cross-elasticity of demand and small but significant non-transitory increases in price, SSNIP analysis. Yes, we need a acronym for that. The determination of a relevant market is a highly factual question. The proper market definition in this case can be determined only after a factual inquiry into the commercial realities faced by consumers. The actual existence of an aftermarket is a factual question, so these are factual questions meaning for a jury to decide. Even if a plaintiff establishes monopoly power in the relevant market under the first element, the courts will not condemn it, unless it is accompanied by an element of anti-competitive conduct under the second element. The mere possession of monopoly power and the concomitant charging of monopoly prices is an important element of the free market system. In other words, if Apple is not acting in an anti-competitive way, then there's still ways for competitors to enter that market. So they have to also prove that Apple is acting in an anti-competitive manner. Thus, courts distinguish between the willful acquisition or maintenance of monopoly power from growth or development as a consequence of a superior product, business acumen, or historic accident. To demonstrate the former, plaintiff must show anti-competitive abuse or leverage of monopoly power or a predatory or exclusionary means of attempting to monopolize the relevant market. To be condemned as exclusionary, a monopolist act must have an anti-competitive effect. That is, it must harm the competitive process and thereby harm consumers, in contrast to harm to one or more competitors, which will not suffice. Anti-competitive conduct is evaluated under the rule of reason. First, plaintiff must show diminished consumer choices and increased prices as the result of a less competitive market due to either artificial restraints or predatory or exclusionary conduct by the defendant. Then, if a plaintiff successfully establishes a prima facie or basic case by demonstrating anti-competitive effect, then the monopolist may offer a pro-competitive justification for its conduct. For example, the monopolist may show that its conduct is a form of competition on the merits because it involves, for example, greater efficiency or enhanced consumer appeal. Finally, if defendant offers a non-pretextual pro-competitive justification, the burden shifts back to the plaintiff to rebut defendant's claim or demonstrate that the anti-competitive harm of the conduct outweighs the pro-competitive benefit. Last, if plaintiff satisfies the first and second elements of monopoly power and willful maintenance or acquisition of that power in the relevant market, the last element of causation may be inferred when exclusionary conduct is aimed at producers of nascent competitive technologies, as well as when it is aimed at producers of established substitutes. Relevant market analysis. In summary, the record does not yet establish how the relevant market should be defined. Without a definition of the relevant market, the existence of market power, the foundation of a monopolization claim, cannot be assessed. Accordingly, Epic Games has not yet shown that it will likely succeed on the merits of the monopolization claim. The relevant market must include both a geographic market and a product market. Unsurprisingly, the parties disagree on the product market. Epic Games avers that the relevant product market is the market for distribution of apps on the iOS software platform, which it refers to as the iOS app distribution market. Thus, Epic Games narrows the relevant market to consider only how iOS apps are distributed on the iOS platform. Apple, meanwhile, asserts that the relevant product market must include competing platforms on which Fortnite is distributed and monetized. In other words, Apple argues that the court must consider the wider video game market and distribution on other platforms, including the Xbox, PlayStation, Switch, and PC and macOS computers, tablets, including Android and Microsoft. Thus, Apple seeks a broader market definition that includes the distribution of video games across all video game platforms. Ultimately, the court must discern where competition exists and whether such competition is sufficient to impact price and discipline market players. Epic Games' relevant market definition that iOS app distribution is an aftermarket of the smartphone OS market is plausible. However, in some ways, Epic Games offers a fail-safe definition by restricting the market so narrowly. By definition, Epic Games' proposed market definition excludes other smartphone systems, including Android, as well as video game platforms and their digital distribution markets. Courts have expressly cautioned against such a narrowing of the relevant market definition. See DuPont. A retail seller may have, in one sense, a monopoly on certain trade because of location, or because no one else makes a product of just the quality or attractiveness of his product. Thus, one can theorize that we have monopolistic competition in every non-standardized commodity, with each manufacturer having power over the price and production of his own product. However, illegal power must be appraised in terms of the competitive market for the product. See SciStar, manufacturers' own products do not themselves comprise a relevant product market. Moreover, Apple avers that an aftermarket requires user lock-in in the primary market. Given the lack of legal citation, the court surmises that this theory has not been adopted by any court, even if embraced by economists. The term lock-in appears to derive from the Supreme Court mention that if the cost of switching is high, consumers who have already purchased the equipment and thus are locked in will tolerate some level of service price increases before changing equipment brands. In evaluating Epic Games' response, resolution of the issue is focused on timing. Apple argues that consumers are not locked into the purchase of iPhones, while Epic Games assumes the purchase and argues that after the purchase occurs, the consumer is locked in and unlikely to switch to a different smartphone in response to slightly more expensive IAPs. Under the latter perspective, app developers who wish to reach iOS users have no choice but to tolerate Apple's 30% rate. Thus, at this stage of the litigation, and with the record before the court, Apple's relevant market definition is also plausible. As Apple correctly points out, alternative means exist to distribute Fortnite. Indeed, Epic Games expressly advertised the multi-platform nature of its product following its breach of the Apple Terms of Service. The party continues on PlayStation 4, Xbox One, Nintendo Switch, PC, Mac, GeForce Now, and through both the Epic Games app at epicgames.com and the Samsung Galaxy Store. The multi-platform nature of Fortnite suggests that these other platforms and their digital distributions may be economic substitutes that should be considered in any relevant market definition because they are reasonably interchangeable when used for the same purposes. If competitors can reach the ultimate consumers of the product by employing existing or potential alternative channels of distribution, it is unclear whether such restrictions foreclose from competition any part of the relevant market. Epic Games' arguments distinguishing these other platforms as potential economic substitutes have not been sufficiently tested. First, Epic avers that the iOS market is distinct from other video game platforms because Sony, Nintendo, and Microsoft do not make much profit, if any, on the sale of the hardware or console, unlike Apple, which allegedly makes significant profits on the sale of each iPhone. This distinction is without legal precedent under Section 2 of the Sherman Act. Indeed, Sony, Nintendo, and Microsoft all operate similar walled gardens or closed platform models as Apple, whereby the hardware, operating system, digital marketplace, and IAPs are all exclusive to the platform owner. As such, a final decision should be better informed regarding the impact of the walled garden model, given the potential for significant and serious ramifications for everyone, Sony, Nintendo, Microsoft, and their video game platforms. Second, Epic Games avers that the iOS platform is unique from other gaming devices. Specifically, Epic Games argues that gaming consoles and computers require electrical outlets and separate screens and thus lack capacity for mobile play, which demands portable battery-powered and cellularly connected devices with built-in screens. Yet Epic Games repeatedly ignores discussion of gaming laptops, tablets, Nintendo Switch, all of which can be played in a mobile fashion. These devices could have significant overlap with the iOS platform in terms of the ultimate consumer. Again, however, at this stage, the record does not contain sufficient information to determine whether such other devices are economic substitutes or merely complementary to iOS devices. Thus, and for other reasons, Apple's market definition also faces hurdles. Antitrust law is not concerned with individual consumers or producers like Epic Games, it is concerned with market aggregates. Substitutes may not deprive a monopolist of market power if they fail to affect enough consumers to make a price increase unprofitable. Alternatively, constraints among some consumers may not render the market as a whole narrow. Here, both parties cite factors impacting the elasticity of their proposed markets. A final determination may depend on the magnitude of those effects. For instance, focusing on Fortnite alone, the record shows that 1. More than 116 million of 350 million Fortnite players have accessed Fortnite through the iOS platform, and 2. iOS players constitute roughly 10% of the daily active Fortnite users since its iOS launch in April of 2018, and 3. 63% of Fortnite players on iOS only play on the iOS platform. Notably, the record is silent on how often these 116 million individuals play Fortnite and devoid of information on the characteristics of the 10% of daily active users and whether those users access Fortnite through other platforms. Seems convenient. More broadly, there is no evidence regarding the size of the game app market compared to other apps and whether they constitute a separate submarket with unique characteristics that do not apply to other app developers. Thus, the market definition rests on factual questions regarding the nature of the iOS market as a whole. How many iOS users own multiple devices? How many iOS users would switch to another device in response to a price increase? How many producers can afford to forego iOS customers altogether? Neither party adequately addresses these factual questions. Epic Games assumes all iOS customers are the same, and Apple assumes that only Epic Games customers are relevant. Moreover, underlying these questions is a significant and unresolved dispute over clustering. Apple focuses narrowly on game distribution channels because of the nature of Epic Games' business, but courts have often combined different services together when the product package is significantly different from and appeals to buyers on a different basis from the individual products considered separately. For example, in United States versus Phillipsburg National Bank and Trust, the Supreme Court grouped multiple financial services together into a relevant market of commercial banking, even though they differed in their availability of substitutes because customers generally obtain all banking services from one place. Here, Epic Games may establish that app distribution generally should be considered separately from app distribution of individual games. which could have a significant impact on how alternative distribution channels are evaluated. Finally, underlying each of these issues is the question of perspective. Interchangeability for purposes of the relevant market may vary depending on perspective. Here, there are at least 3 possible perspectives on the relevant market. 1, the customer who purchases the apps or games, 2, the developer who makes the apps or games, and 3, the competing app store or digital marketplace that distributes the apps or games. The parties adopt different perspectives, but neither justifies its choice. As the parties' briefing demonstrates, the resolution of this question could lead to radically different analysis. In short, without the record to define a relevant antitrust market, Epic Games has not established likelihood of success as to monopoly maintenance, only serious questions. Further, without such definition, the court need not evaluate the second or third elements of the Section 2 claim. Additionally, even under a Section 2 claim, plaintiff must show anti-competitive conduct. One way to do so includes a rule of reason analysis. Given the overlap of this issue with a Section 1 claim, the court addresses that below. Tying under Section 1 of the Sherman Act. Tying arrangements under Section 1 of the Sherman Act may be evaluated under either the per se or rule of reason analysis. Per se analysis allows condemnation without inquiry into actual market conditions based on precedent that deems certain contractual arrangements unreasonable as a matter of law. For a tying claim to suffer per se condemnation, a plaintiff must prove that 1, the defendant tied together the sale of 2 distinct products or services, 2, that the defendant possesses enough economic power in the tying product market to coerce its customers into purchasing the tied product, and 3, that the tying arrangement affects a not insubstantial volume of commerce in the tied product market. An example that keeps cropping up in my mind is think of something that has inelastic demand like healthcare. Let's pretend you have to buy your healthcare from one healthcare provider. And so they say, well, in order to buy healthcare from us, you must also buy a car from us. That's tying. They're unrelated. The economic power, the market power of the healthcare insurance provider or whatever, makes it unreasonable for you to have to buy a car in order to get healthcare. You must basically bypass competition in the car sales market in order to get something that you need, otherwise healthcare. So that's a stupid example, but it should be a clear example. I don't think any healthcare company is going to make you buy a car, but if they did, that would be some kind of anti-competitive tying. To assess the first element, courts apply the purchaser demand test, which examines direct and indirect evidence of consumer demand and whether a defendant foreclosed competition on the merits in a product market distinct from the market for the tying item. Direct evidence of demand includes whether, when given a choice, consumers purchase the tied good from the tying good maker or from other firms. Indirect evidence includes firm behaviors. For instance, a single product is apparent if competitive firms always bundle the tying and tied goods together. A tie requires a condition linked to a sale. The second element of forcing or coercion is likely if the seller has power in the tying product market. The third element asks simply whether a total amount of business substantial enough in terms of dollar volume so as to not be merely de minimis is foreclosed to competitors by the tie. If a plaintiff fails to establish per se liability, a plaintiff must demonstrate that a defendant violated the Sherman Act because it unreasonably restrained competition under the rule of reason. The rule of reason requires courts to conduct a fact-specific assessment of market power and market structure to assess the restraint's actual effect on competition. Recent cases suggest that the rule of reason applies to any tying claim that involves software that serves as a platform for third-party applications. The 3-part burden-shifting test under the rule of reason is essentially the same for Section 1 as for Section 2 claims. The plaintiff has the initial burden to prove that the challenge restraint has substantial anti-competitive effect that harms consumers in the relevant market. That said, the court need not consider whether competition was in fact unreasonably restrained. Second, if the plaintiff carries that burden, then the burden shifts to the defendant to show a pro-competitive rationale. Finally, if the defendant makes this showing, then the burden shifts back to the plaintiff to demonstrate that the pro-competitive efficiencies could be reasonably achieved through less anti-competitive means. Per se tying analysis. Epic Games avers that Apple ties the iOS app distribution product, over which Apple has economic power, to a separate product of the IAP in-app purchase system. Based on the current record, the court concludes that Epic Games has not yet shown that the IAP system is a separate and distinct service from iOS app distribution sufficient to constitute a tie under antitrust law. Where the allegedly tied product is an essential ingredient of the overall method of business with customers, courts view them as one product and not as two tied together. This is especially true where the allegedly separate products have always been integrated. As the Ninth Circuit has recognized, payment processing can be part of a single integrated product. Here, the IAP system appears to be integrated with the App Store and, historically, to have never been a separate product. If so, the constraint of the IAP appears to reinforce the notion that the App Store is a digital marketplace where developers on the App Store are able to structure their business models however they choose. Many of these developers, like Epic Games, structure these models so that the game or app is free, presumably to entice customers to download the game or app initially, only then to monetize the subsequent in-app purchases. The IAP system does not appear to be a payment processor in the same way that Visa, MasterCard, or PayPal is a payment processor. It is more akin to a link back to the App Store where the transaction must occur within the digital confines of the App Store. The IAP system appears to have been created in part to capture the value of a developer being on the digital shelf of the App Store, which is owed to Apple either on the initial download or in subsequent IAPs. Nevertheless, Epic Games raises serious questions about the existence of separate demand for IAP-type services. Payment processing markets are ubiquitous outside of IAPs. Epic Games offers indirect evidence of separate demand through analogy to these markets, including the markets for the sale of physical goods sold through apps on the iOS platform. The experts disagree over whether the distinctions between IAP and these payment processing services actually impact consumer demand. Moreover, Epic Games provides evidence that developers have demanded their own in-app purchase payment processing services. Epic Games further points to evidence in the record demonstrating that some customers choose to use Epic Games payment processing service when given the choice with IAP. So maybe that's what they were trying to do, was establish a little bit of evidence that people actually did want to use Epic's processing system. But of course, Epic's processing system did not incur the 30% penalty, and so therefore they lowered the prices by like 20 or 30% or something. So if you were given a choice to buy $10 worth of Fortnite points, I don't actually play Fortnite, I don't know what it is, at $10, or if suddenly you could buy $10 worth of Fortnite points at $7, of course you're going to buy it at $7. That's a little bit disingenuous though, because Epic did that underhandedly and not through actual competition. It is not surprising that some customers would choose competing payment services if they provided lower prices offered only because of this non-payment. This does not evidence separate demand for payment processing services as much as a demand for alternatives to Apple's integrated services of iOS app distribution. When framed in this way, Epic Games' argument is no more than a collateral attack on Apple's App Store model, not a demonstration of separate demand. In this respect, Epic Games' strongest argument, left woefully underexplored in the record, lies with competition on other features provided by IAP, such as customer service, parental controls, and security. This evidence suggests that a more fully developed record could plausibly show demand for a separate product. Should Epic Games satisfy the purchaser demand test for finding distinct products, it may prevail on the remaining elements under the per se tying analysis. While Apple claims that it does not tie IAP to iOS app distribution because developers may choose other business models, it does not dispute that its App Store review guidelines require the IAP system's use for IAPs as a condition of app distribution. This requirement manifests the coercion, that is, developers who offer IAP must do so on Apple's terms. Apple also does not dispute that it holds market power in the iOS app distribution market and that the alleged tie affects a substantial volume of commerce in in-app payment processing. Accordingly, Epic Games raises serious questions with regard to per se tying, but fails to demonstrate the likelihood of success due to the lack of evidence of purchaser demand for IAP processing service separate from the integrated service of app distribution. The rule of reason analysis. The rule of reason analysis is more fact-specific than the per se analysis. Here, the first element focuses on the harm to competition and consumers. Epic Games errs by focusing on harm to competitors, and for that reason has not sustained its burden at this juncture. Even if it had, Apple of course offers a pro-competitive justification consistent with step 2 of the 3-part burden-shifting analysis. Apple claims that the IAP provides the business mechanism for it to be paid for the App Store given its support of 1.8 million apps, of which 84% are free, to 1.5 billion Apple devices and 900 million iPhone users. Apple claims that IAP also provides 1. A centralized, convenient way to transact online, 2. Security and fraud protection, 3. Refunds and customer support from Apple, 4. Parental controls, and 5. Comprehensive lists of purchases, all of which are facially reasonable. That developers may not want to pay a commission or licensing fee does not necessarily translate to antitrust behavior. Under a rule of reason analysis, then, the burden shifts back to Epic Games to demonstrate that the pro-competitive efficiencies could be reasonably achieved through less anti-competitive means. Here, the record is not fully developed and mixed at best. Competitors could conceivably provide equal or superior services. Indeed, it is entirely plausible that app developers could provide better refunds and customer support for goods purchased through their own apps than Apple can, or not. As noted, the sale of physical goods sold on iOS already uses separate payment processors or mechanisms outside of the IAP system. On the other hand, Apple has produced evidence that its security features are more effective than its competitors, a basis on which it competes. Thus, the dispute likely comes down to whether these features and Apple's monetization can be achieved through less anti-competitive means. The record on these issues is thin, as is any briefing on the method of proof given the frontier on which the questions sit. Summary. For the reasons set forth below, Epic Games has shown that serious questions exist with respect to its Section 1 and Section 2 claims against Apple, but has not proven a likelihood of success on the merits on this record. So that's only part of it. We still have 12 pages of this to go, so the next section is going to be irreparable harm. As the court stated in the temporary restraining order, the issues of irreparable harm focus on the harm caused by not maintaining the status quo, as opposed to the separate and distinct element of a remedy under the likelihood of success factor. Here, once again, the court's evaluation is guided by the general notion that self-inflicted wounds are not irreparable injury. Further, courts generally decline to find irreparable harm that results from the express terms of the contract. Sorry, I'm getting excited because this is what I keep saying, that they shouldn't get a preliminary injunction because they have unclean hands. Epic should not get what it wants yet because it started by inserting code into Fortnite that bypassed its contracts with Apple. You go to court first. Quite simply, irreparable harm is harm or injury that cannot be repaired. Epic Games contests the court's prior determination with respect to Fortnite, namely that no irreparable harm exists where Epic Games chose to breach its agreements with Apple in enacting its own direct IAP system. Epic Games cites to precedent involving affirmative defenses to argue that the court should not aid in the enforcement of contracts that are anti-competitive and violative of antitrust laws. The authorities from earliest times to the present unanimously hold that no court will lend its assistance in any way towards carrying out the terms of an illegal contract, etc. Epic Games concedes that these affirmative defenses are procedurally not at issue. Instead, it claims it should not be penalized for defying Apple's monopolistic edicts, and that the court should proactively extend the principle in support of Epic Games' proffer of irreparable injury. Epic further avers that ongoing harm continues to its reputation, the Fortnite gaming community, and its ongoing ambitions in the creation of a metaverse. In support, Epic Games introduces declarations attesting to a 60% decline in the number of iOS users in Fortnite, and that those who continue to play are doing so for significantly fewer hours per week, given that these players are stuck on an earlier version and unable to play with other individuals. But they did it to themselves. They violated the agreement first and then went to court. You go to court first, you get the preliminary injunction or the temporary restraining order, then you can go and violate the terms with the court's endorsement. Next, Epic Games provides records reflecting customer complaints and online comments about the unavailability of Fortnite on the iOS platform. Indeed, Epic Games argues that many of these customers blame Epic Games for being cut off from access to Fortnite. Finally, Epic Games includes declarations attesting to difficulty in creating and sustaining a metaverse in the Fortnite community, given that it is no longer on the iOS platform. What? They can't create their copyrighted creation because they don't have access to one platform, which represents 10% of users? That doesn't make any sense. Epic Games does not persuade, so the judge is not persuaded either. The cited cases are singularly premised on the fact that the consequences from a breach of contract in which the parties are seeking to escape are actually in violation of antitrust laws in the United States. As discussed, the court has made no such finding in this order as to Epic Games' likelihood of success on the merits, beyond only finding serious questions. This is especially so where the alleged monopolistic practices and conduct concern innovative technology platforms without analogous prior precedent. Moreover, the court considers countervailing interests in ensuring that antitrust laws are not otherwise stretched into areas that are beyond what is required or contemplated. Obviously, federal courts should not be quick to create a policy of non-enforcement of contracts beyond that which is clearly the requirement of the Sherman Act. The purpose of the antitrust law deals with promoting competition, not with extending unsatisfactory contractual relationships beyond their stipulated periods of effectiveness. In short, Epic Games cannot simply exclaim monopoly, "I declare monopoly," to rewrite agreements giving itself unilateral benefit. In other identified bases, damage to its reputation and the Fortnite gaming community cannot constitute irreparable harm where such harm flows from Epic Games' own actions and its strategic decision to breach its agreements with Apple. While consumers are feeling the impact of this litigation, the fact remains these are business disputes. A putative class action on behalf of all developers on these exact same issues was already in progress when Epic Games breached the agreements. Yet Epic Games has never adequately explained its rush, other than its disdain for the situation. The current predicament is of its own making. Only the injury inflicted by one's adversary counts for this purpose. Epic Games remains free to maintain its agreements with Apple in breach status as the litigation continues and ignore what the Seventh Circuit recognized in Second City Music. The sensible way to proceed is for Epic Games to comply with the agreements and guidelines and continue to operate while it builds a record. There is no loss of face if one's goal is to protect its consumers, the Fortnite player base. To assist, the court even offered to require the 30% to be placed in escrow, pending resolution of the trial, which Epic Games flatly rejected. The refusal to do so suggests Epic Games is not principally concerned with iOS consumers, but rather harbors other tactical motives. Certainly, no technical issue exists. Epic Games admits that the technology exists to fix the problem easily by deactivating the hotfix. Thus, given the totality of these circumstances, the court can easily find that the injury Epic Games incurs by following a different course is of its own choosing. It is self-harm caused by self-help. Accordingly, Epic Games has failed to demonstrate irreparable harm as to Fortnite and the games under the Epic Games developer account. And then they go on to the affiliates, and I think for time considerations, I'm just going to summarize this. The affiliates are victims of this whole thing, and the affiliates get to stay in. So the Unreal Engine stays in. The third-party developers who use Unreal Engine, they get to stay in. They are not kicked out of the App Store. But let's just see by skimming if there's anything in here that's interesting. With respect to the Unreal Engine and affiliates, the court concludes that Epic Games has made a sufficient showing as to the irreparable harm. The court previously found Apple is hard-pressed to dispute that even if Epic Games succeeded on the merits, it could be too late to save all the projects by third-party developers relying on the engine that were shelved while support was unavailable. Indeed, such a scenario would likely lead to nebulous, hard-to-quantify questions such as how successful these other projects might have been, how much in royalties would have been generated, much less the collateral damage to the third-party developers themselves. In other words, if you are a victim third-party Epic affiliate Unreal developer and you've now lost access to the Apple App Store, and then Epic loses the case, can you sue Epic for having caused your loss, or maybe you can't because there's some contract that you signed that indemnifies Epic or something like that. And if you win, are you then getting your money from Apple, and exactly how much? How are they going to be able to show how much they lost? Do you sell more at Christmas time? Do you sell more in the summer? What did you lose? So these are really nebulous questions, and I agree with the court. There is ample evidence in the record demonstrating that the removal of developer tools would have significant irreparable harm to Unreal Engine and to Epic Games and its affiliates, and that Apple's threat to revoke the developer tools from Unreal Engine is already having a negative impact on Unreal Engine. So that's how that plays out there. So then the court goes on to the balance of equities. As the court stated in its prior order, the battle between Epic and Apple has apparently been brewing for some time. It is not clear why now became so urgent. The Cameron case, which addresses the same issue, has been pending for over a year, and yet both Epic and Apple remain successful market players. If plaintiffs there or here prevail, monetary damages will be available, and injunctive relief requiring a change in practice will likely be required. Epic Games moves this court to allow it to access Apple's platform for free while it makes money on each purchase made on the same platform. While the court anticipates experts will opine that Apple's 30% take is anti-competitive, the court doubts that an expert would suggest a 0% alternative. Not even Epic Games gives away its products for free. Thus, in focusing on the status quo, the court observes that Epic Games strategically chose to breach its agreements with Apple, which changed the status quo. No equities have been identified, suggesting that the court should impose a new status quo in favor of Epic Games. The court finds that the balance of equities weighs towards Apple, where Epic Games breached both its agreements and the guidelines, and an injunction would potentially incentivize similar breaches. In sum, no equities have been identified, suggesting the court should impose a new status quo. But as to the Epic affiliates, the court relies on what it previously found, which we won't go over here for sake of time. Public interest. The public interest inquiry primarily addresses the impact on non-parties rather than parties. The plaintiffs bear the initial burden of showing that the injunction is in the public interest. The current briefing does not change significantly, which the court reaffirms. With respect to the gaming requests, the court recognizes that numerous internet postings and comments submitted by Fortnite players are passionate supporters of the game and eagerly anticipate its return to the iOS platform. The court further recognizes that during these coronavirus pandemic times, virtual escapes may assist in connecting people and providing a space that is otherwise unavailable. However, the showing is not sufficient to conclude that these considerations outweigh the general public interest in requiring private parties to adhere to their contractual agreements, or in resolving business disputes through normal, albeit expedited, proceedings. With respect to Unreal Engine, the record shows potential significant damage to both Unreal and the gaming industry generally. As to Fortnite, nothing has changed, so they're going to maintain the public interest factor weighs in favor of Apple because Fortnite or Epic breached their agreement. And the record is also unchanged about affiliates, so the court is going to find that the public interest is in favor of Epic on the Unreal Engine affiliates. In sum, the court finds that based upon the record before it, the winter factors weigh against granting a preliminary injunction based on Epic Games' requests as to Fortnite and other games, and in favor of granting a preliminary injunction order as to the Epic affiliates' affected developer tools, including Unreal Engine. The court grants in part, denies in part, the preliminary injunction. Therefore, here's the order. Apple and all persons in active concert or participation with Apple are preliminary enjoined from taking adverse action against the Epic affiliates with respect to restricting, suspending, or terminating the Epic affiliates from Apple's developer program on the basis that Epic Games enabled in-app purchases direct processing in Fortnite through means other than through the IAP system, or on the basis of the steps Epic Games took to do so. This preliminary injunction shall remain in effect during the pendency of this litigation unless the Epic affiliates breach any of their governing agreements or the operative App Store guidelines. This preliminary injunction supersedes the prior temporary restraining order. For the reasons set forth above, this preliminary injunction is effective immediately and will remain in force until the disposition of this case. Neither party has requested a security bond, and the court finds none is necessary. It is so ordered. Yvonne Gonzalez-Rogers, United States District Judge, October 9th, 2020. Boom! Maybe I should do that again from other angles. Hit myself in the head with this thing a number of times because that's what I feel like Epic Games is doing, is just bonking themselves in the head with their own illegitimate, unclean hands, self-help actions, ignoring their contractual obligations because they just assume the court will agree that Apple is acting in an anti-competitive manner in violation of antitrust laws. There's no legal precedent for it, as the court has said. So Epic and their very expensive attorneys should know better than to just go ahead with a inserting of a hotfix to bypass the Apple App Store terms of service, for lack of a more precise term, for lack of a shorter term. And that just means that Epic came to the court with unclean hands, and so they really can't get what they want. What they should have done, as I've said before, is file the lawsuit and then ask the court to endorse the changes with Fortnite being allowed in the store. And whatever the monetary damage is, that's the monetary damage. Then it would only be monetary damage at issue. The court even points out that there's another lawsuit that's already in process for a year. So why Epic wouldn't just join that lawsuit is also indicative of their unclean hands and their self-serving nature. So Fortnite, Epic did this to themselves. Fortunately, the judge recognizes that the Unreal Engine and Epic affiliates did not do it to themselves. And so the status quo is maintained by this preliminary injunction. I think this is the right ruling. I'm very eager to. I definitely want to hear what the ultimate resolution is going to be and whether Apple is considered to be anti-competitive. I know that Apple makes a quality product. I was an Apple supporter for many years. I was a diehard Apple fanboy since 1987, since I got my first Macintosh LC. I only turned to the dark side of PCs because, one, the machines are more customizable. I can build a machine that's compatible with Windows and then just install Windows. But you can't tell me that Windows is a quality product. You're just not going to convince me. I have so many problems with Windows that you just can't convince me that it's a quality product. It works well enough, but I have to go put in so many hours of troubleshooting and fixing things. Last year, I don't know if you remember, I was really upset that my Microsoft branded Surface Book 2 got a update from Microsoft through the Windows platform that disabled the built-in NVIDIA graphics card when I was in the middle of editing. And then I found out that there was only, I think it was a 95 watt power supply supplied with a laptop that could use well over 150 watts. And that meant that it had to drain the battery while you were using the laptop plugged in. And there was no option to get more power to the thing. So if I needed to edit for longer than 6 hours, which would include writing, shooting, and editing, and then maybe some video gaming in there or something, the laptop would just shut off or go into a power saving mode, and you just could no longer work with it anymore. That was so ridiculous. I had threatened to sue Microsoft over the misrepresentations, but I found somebody to buy my laptop instead and bought something way more powerful that I worked with for a year, an Asus ZenBook Pro Duo, and now I have a tower sitting here that I just built here in Europe. Got a 3080, and I'm quite happy with everything, so I no longer have any reason to go after Microsoft other than just roasting them from time to time about how their product sucks as well sometimes. Both companies have their downsides. If I could survive with building my own Linux distribution and still have access to all the Windows programs that I need, great, but I think I'm going to have just as much trouble getting that to run and troubleshoot, and so I think Windows is the answer to my solution, or the solution to my troubles for right now. We'll see what happens with this lawsuit. Let me know what you think in the comments below. I'll see you in the videos. Thank you. And that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, on Floatplane, and on Twitch. Thank you to our supporters on patreon.com/ljfrench and sponsors.com/law. In the month of October, thank you to our $50 plus supporters who get called out by name: Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Stephen, Goliath Cleric, Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., J. Dixon, Hot Grills in Your Area, Oscar the Phrophet, Brandyn, Abel, torpedan, IANAL, which means I am not a lawyer. Of course, I am a lawyer, but that's a friend of mine who is having fun with us, Cassandra, Curran, and Shadow Tycho. And thank you to the $5 plus supporters who are scrolling on the still operating LED panel behind me, and everyone is on this crawl on the screen in front of me, and a description of the videos. I love you all. I will see you in the videos that drop. Have a good one. Bye.
You got me stoned.